Court does call the cases of Arbor One West versus Rico McGuire.
Ellis Brickman for the plaintiff.
Thank you, sir.
Deputy Layman here as well for the plaintiff.
Angela Jackson here on behalf of BL Management.
All right.
Alexander on behalf of the defendants.
All right. Okay, folks. Thank you. I think we had a little mix up in time, but I think everybody's here. And
all right out of the gate, you can already feel what kind of hearing this is going to be. This is not some clean, tidy landlord-tenant dispute where everyone strolls in with a neat checklist and a simple answer. No, this one has the energy of a property crisis that has already outgrown the courtroom. Judge Simpson is walking into a room full of lawyers, property managers, city concerns, inspection disputes, repair deadlines, and tenants whose housing situation is hanging in the balance. And that opening line matters because it tells you the court knows this thing is sprawling. There's confusion, there are multiple moving parts, and the judge is essentially asking the most important question in the room: where exactly do things stand right now? That's the real tension here. Not, did someone miss one repair, but whether this property team is actually on track to fix serious compliance issues before the deadline hits. Because once you start hearing words like permits, inspections, city requirements, boiler issues, relocation, and escrow in the same case, this stops being routine management drama and starts becoming a full-blown systems failure story. And Judge Simpson knows it. He's not here for vague optimism. He's here to pin people down on what's been done, what hasn't, and who's responsible if this all blows up by the 20th. So as this hearing unfolds, watch for the pattern. Every side is going to say, progress is being made, but the real question is whether that progress is real, documented, and fast enough to matter.
I'm almost afraid to ask, where are we?
Oh.
Go ahead, Mr. Freeman.
I was just going to say that there has been significant progress made. There's been some, I guess I'll say, stumbles along the way, but significant progress is being made, I think, on schedule. The fire doors that were in question did arrive, are being installed. There are some issues with inspections and building permits that need to be ironed out. I don't believe any due to any fault of the property manager, but my co-counsel has been very actively involved dealing with the property manager, communicating directly with the property manager, and I think is better prepared, informed, I should say, really, to address the issues that are still remaining. But that being said, we do believe we can meet that schedule that was set previously.
Yes, Your Honor. As Ellis indicated, fire doors are ordered. As you know, we submitted the plan to you at the last hearing.
Yes.
There were a number of permits that the city was requiring the property manager to pull. Those have been pulled. My understanding is on May 2nd, there were 13 building permit inspections scheduled. 12 of them were passed on that day. There was one that did not pass due to, I believe, the drywall not being painted at the time. But the
drywall not being painted.
Yes. Yes. So the 13th one failed because the drywall was not primed yet. FDIC, the vendor, had a hard time getting the mud to dry with the tenant taking a steamy shower, so it was not able to be painted. They requested to have a photograph of it being primed, sent to the city within maybe, I believe it was like 30 minutes after, and they were told that they could not do that. So they had to reschedule it for a new inspection, which I believe, Stuart, was that new inspection done?
And this is where the case starts showing its personality. Everything is allegedly moving forward, but every single step seems to come with an asterisk. 12 out of 13 inspections passed sounds good, until you realize the one failure wasn't some tiny paperwork typo. It was a failed inspection tied to unfinished work, and that failure immediately creates a ripple effect. Rescheduling, more waiting, more dependency on city timing, and less room for error before the deadline. That's the kind of thing that can quietly derail an entire compliance timeline. What's also striking here is how the explanation lands in court. The defense side is basically saying, look, we were close, the drywall wasn't primed in time, the shower humidity slowed the mud drying, and now we just need another inspection. Technically, that may be true, but in a hearing like this, the judge isn't grading effort, he's grading results. The court doesn't really care how close you were to passing if the clock is ticking and the building still isn't cleared. That's the difference between a construction excuse and a courtroom problem.
It's on for this weekend.
Okay, so that new one is scheduled for this week. There was the scope testing that was to be done on areas. They received a proposal from TEK Environmental. The proposal was executed by the ownership and they're just waiting for scheduling for that from TEK. So that is in the works to be completed. There were 2 items with electrical permits for 2 of the units in 721 Clark. The property manager is hiring LR Rolls Mechanical to pull electrical permits and schedule those inspections. Similarly, with a ceiling fan that was in a unit within 721 Unit 206, LR Rolls is being hired to pull the electrical permits for that as well.
But those electrical, they haven't been pulled as of yet, but you've hired somebody to.
Yeah, so the idea is that the company comes in and pulls the permits during that process. So they're working on hiring LR Rolls to do that. There was also, there's this boiler boiler letter and baseboard covers. There was a request by the city that we provide them with a boiler letter. Basically, that would attest to the fact that boilers are in working condition. The boiler letter had previously been sent to the city on March 17th, April 8th, and April 29th. We received a correspondence from the city on the 29th saying that the letter needed to be signed and dated per building, and that the letter did not have the building addresses on it. And so a new letter was provided to the city, and it was indicated that the signature was not a wet signature on the letter, and that the person doing the inspection is not the license holder.
Now, this is the kind of detail that sounds boring on paper but becomes a major courtroom headache in real life. Because what we're hearing here is not simply, we sent the boiler letter and the city rejected it. We're hearing a chain of technical objections. The letter wasn't signed the right way, it didn't have the building addresses, the signature wasn't a wet signature, and now there's a question about whether the actual inspector named in the letter is even the proper licensed person. That is a nightmare if you're trying to hit a deadline. And here's why this matters. In housing compliance cases, especially when the court is monitoring whether units can remain occupied or be brought back into compliance, documentation is not a side issue. Documentation is the work. You can physically inspect the boiler. You can believe the boiler works. You can even have a contractor who says it's fine. But if the city says the letter doesn't meet the required form, then as far as enforcement is concerned, it might as well not exist. That's the brutal administrative reality of these cases.
So we're trying to get in contact with the contractor so that they can communicate maybe with the city directly to get them what they need. But it seems like.
So the 3 boiler letters, are those for 3 separate boilers?
I believe that the company came in and looked at all of the boiler covers, or maybe Mr. Beal could speak better to this. Can you speak about the boiler letters and what that is?
This is one of the last remaining issues that are going to cause a problem on May 20th. The city is requiring a letter from a licensed boiler contractor to say that the boilers are operational. We provided that letter 4 times over the last 45 days, and it still has not been accepted by the city. And so we're asking the city to accept it in its most latest iteration. But one of the problems is that the boiler system is very expansive and complex. It has 24 apartments in each building, and there are radiator covers in each apartment that Jerry, the inspector, says if they're damaged, they need to be replaced. But
well, I don't need to know what the problem is. What I'm trying to figure out is the letters that were sent. Were those encompassing all of the boilers for these particular units, or what were they encompassing?
So there's one boiler per building, and we've provided 1 letter per building now.
All right. Okay.
So as Mr. Beal indicated, this is going to potentially be an issue coming on the 20th. So the position is that they want all of these base board covers that deal with these boilers replaced. And that is going to be approximately, I believe you said about $20,000 of building.
This is where the money starts talking. And when the money starts talking, the strategy usually gets a lot more honest. Up to this point, the discussion sounds like a technical dispute over inspections, letters, permits, and baseboard covers. But then we get the number, roughly $20,000 per building if they're forced to replace all of these boiler-related covers. Suddenly, the argument snaps into focus. This isn't just, we disagree with the city's interpretation. It's, the city's position could trigger a major repair bill, and ownership wants to avoid spending that if the boilers themselves are operational. That distinction is important. The property side is trying to frame this as a reasonableness issue. If the boiler system works, and only some covers are actually damaged, then why should they be forced to replace everything? That's a fair advocacy move. But from the city's perspective, if the inspection standards aren't satisfied, or if they believe components tied to safety or compliance are deficient, they don't have to care that the replacement is expensive. Cost doesn't erase a code problem. And Judge Simpson's reaction throughout this section is telling. He doesn't want speeches about what the city should do. He wants clarity. What exactly is required? What exactly has been submitted? What exactly remains unresolved? That's classic courtroom control. He's trying to cut through the spin and find the actual bottleneck.
And so to the extent that this letter is saying that these boilers are operational, the property manager and the owner are saying that they will replace the boiler covers that are the most damaged, obviously, but to the extent that they're still working properly, it doesn't seem reasonable to require them to replace every single baseboard cover in order to pass this inspection on the 20th.
And to be clear, the city is not requiring us to replace every baseboard cover, but they're not telling us which baseboard covers they actually want replaced. So that's why it could be an issue on the 20th. So the city should either let that go or tell us.
Why don't you sit down?
Thank you.
You don't need to tell them what they need to do. All right. Okay, go ahead.
Also, the city was requesting a letter regarding pest control. It's my understanding that we have that information, and if it hasn't been provided to the city, the instruction is to provide it today. I believe I saw it at the end of last week, so that letter will be provided to the city.
Indicating that somebody's been hired to do it or that it's been completed.
It would be the contract for the pest control, letting them know when they're coming out, how often, services, things like that. So that'll be provided to the city as well. And then as Mr. Beal, I think, indicated as well with regards to inspections that are happening at the property. Another issue that we've run into recently has been scheduling the inspections and having the city come out to do the inspections. We're requesting inspections for several buildings on certain days, and the communication that they're receiving from the city is that you have this window, we're not calling, we're not going to the office, we're not asking for anybody, somebody be at where they need to be when we arrive. And if we've got 15 buildings scheduled for inspection one day, we don't know where the city is going to come up. So we're dealing with those kind of issues where they're refusing to communicate, and time is of the essence at this point. Everybody at the property is valuable, so having multiple employees camp out for a 4-hour window potentially to see whenever the city arrives, as opposed to a brief phone call, I'm on the way, it's becoming a bit problematic. So we're hoping that permits, to the extent that any additional need to be pulled and inspections need to be done, that this is not going to delay the process. So that's just something we wanted to bring to the court's attention as well.
Here's the bigger problem starting to emerge. This isn't just a repairs case anymore. It's a coordination failure case. Listen to what the property side is saying. They're not just complaining about what needs to be fixed. They're complaining about how inspections are being scheduled, how the city communicates, whether anyone calls ahead, whether staff are forced to sit around for hours waiting, and whether the process itself is slowing down the compliance effort. In other words, they're trying to move the blame from "we haven't completed everything" to "we can't complete everything efficiently because the inspection system is working against us." That's a smart litigation move, because if the deadline is missed, this section lays the groundwork for the defense to say, don't pin all of this on ownership or management, the city's process contributed to the delay. But it's also risky, because courts don't love broad complaints unless they come with specifics and solutions. A judge can sympathize with logistical headaches while still saying, fine, but are the buildings compliant or not?
Because that was specifically occurred with regard to those 15 that we had scheduled for May 2nd. So outside of that, I think that those were the main issues that we wanted to point out with regards to the plan and the progress. Oh, there also has been a request for 2 special inspections to occur this week with regards to drywall that needed to be removed. So just in the process of getting the work done, drywall was removed that, they didn't anticipate being removed. So they're requesting special inspections to occur this week so that we can ensure that we're on track for the timeline. There has been no response to that request as of yet, but that request has been made to the city. And that would be the primary things we would want to flag for the plan. We do have a copy of the most current list of items from the correction order that were ongoing from the city, which we can provide to your clerk via email.
Yeah.
It gives a layout of what's been done and then also kind of the plan for getting those things done by the 20th. I just received those, so I don't have a printed out copy, but if that's something the court would like, we can make sure that
Yes, that
emailed to you all. And that is the ones for 720 and 721. So we can make sure that the court has those.
wonderful. All right.
Yes, Your Honor, I had a chance to speak with Mr. Myers about all this, and it does sound like there's some progress being made, but it sounds like because of the fact that they're inspecting the other buildings at the same time, as well as other properties that Beal owns, that they haven't had the chance to get to where they need to be, where they think they're actually going to be on time to make it to the original schedule. I think about half the inspections they've been
What
doing
is
on the
that?
property- About half the inspections they've been doing on the Beal properties or on the Arbor One properties have been for other buildings that aren't these 2 buildings in question. So for that reason, they haven't been able to meet all the requirements that they have to for all the inspections. But I think Mr. Myers should probably speak better about this than I can.
Yeah.
Now the city side steps in, and this is where the hearing shifts from vague progress reports to a battle over prioritization. Because the city's argument is pretty pointed. Yes, inspections have been happening, but too many of them are being spent on buildings other than the 2 buildings at the center of this case. That is a serious accusation in context. Why? Because if these 2 buildings are the emergency, then every inspection slot used elsewhere can be framed as time taken away from the actual crisis. This is one of those moments where both sides can sound reasonable at the same time. Ownership can say, we manage multiple problem properties and we're trying to address them across the board. The city can say, that may be true, but this court is focused on these specific buildings and your own choices are diluting the effort. That's the tension. Is the property team responsibly handling a larger portfolio of issues, or are they failing to triage the emergency in front of them? Legally, this matters because courts care about compliance plans not just in theory, but in execution. If the defense is telling the judge, we can still hit the deadline, and the city is saying, you're not even devoting enough inspection capacity to the 2 buildings that matter most, that undercuts credibility. And once credibility slips, every future promise gets harder to sell.
Yeah, over the last 3 weeks, we have done about 73 inspections at Arbor One. 38 were on these 2 buildings, so roughly half. 16 were approved, canceled, or not ready, disapproved, so they're failing a little over 10% of all of these inspections. They're scheduling inspections for other properties that Mr. Beal owns and not these buildings, which is taking up our inspectors' time away from being able to inspect these buildings, to where next week we have 5, or this week we have 5 open inspections, 1 on Tuesday, 1 on Thursday, and 3 on Friday. The special inspections that they requested on Friday at the end of the day are for times that we don't have inspectors working or that we don't inspect. because they asked for one on Friday at the end of the day at about 4, I think, and then Monday at the end of the day when we don't have an inspector. So we have 8 permits scheduled for this week to be done. There's about 20 that needs to be done. And so we have done whatever we can to make this happen. As far as the inspection, we give everyone a window. We have been told that we treat people differently, but we give everyone the same 4-hour window for inspections. And then we've also said on several occasions that we're going to always start at 721 Clark. It's the first address. That's not good enough for them, but that's really what we can do. But yeah, it's very concerning that out of
What's not good enough? What do you mean that's not good enough?
so they would like the exact time that we're showing up when we really don't know when that is because the inspections happen all throughout the city. But yeah, so this week we have 16 or 14 inspections scheduled for Arbor One, but only 8 of them are on this building, these 2 buildings. So seems like they're prioritizing other buildings over these 2 buildings.
That line right there is an accusation with teeth. They're prioritizing other buildings over these 2 buildings. That's not a technical disagreement. That's the city effectively telling the judge that ownership's own choices are sabotaging the compliance deadline. And if that's true, it changes the entire tone of the case. Because then the story is no longer, we're trying our best, but the process is messy. It becomes, you were told exactly which buildings were the emergency, and you still spread your resources elsewhere. Now, to be fair, property management isn't running one apartment in a vacuum. They're dealing with a larger complex, other citations, other units, and likely a bunch of fires to put out at once. But from the court's perspective, none of that overrides the core issue. These 2 buildings are the ones under the microscope. These are the buildings tied to the hearing, the timeline, the scrutiny, and the consequences. So when the city says only 8 of the scheduled inspections are even for the buildings at issue, that's the kind of number a judge remembers. What makes this especially interesting is that Judge Simpson doesn't blindly swallow the accusation. He pushes back. He starts probing whether this is truly prioritization or simply the reality of a broader repair effort. That matters, because he's not letting either side turn slogans into facts. He wants the mechanics, not the drama.
Why do you say that?
Because if these 2 buildings are the only concern, which we've been told in an email from Mr. Beal that the city's only concern is approving these inspections, they're prioritizing other buildings in the complex
Yeah, but
permits.
what's going to happen is that if they don't, I don't know if that's a prioritization. It's that this is sort of an ongoing concern.
Mhm.
So if I'm working over here, because that may be my next phase that I'm going to try to get some things done, then I would be trying to do them both at the same time.
But we only have a limited number of inspections we can do in a day. And so by taking them away from these 2 buildings, we're being pulled from those 2 buildings.
Okay. Regarding that,
Your Honor, if I may, I find that statement incredibly problematic because if we weren't doing work on other buildings, I mean, property's actively being cited by the city and other buildings as well. So we're splitting time and I don't see that as a problem, but as Mr. Myers indicated, the majority of those requests were for these 2 buildings. So also last hearing, Your Honor, you were inquiring with the city with regards to I guess the 3rd-party contractor that comes in and does certain permit inspections and things of that nature. Since that hearing, we have spoken with one of their representatives, Jeff Schaefer, individual who does the building permit inspections typically for Arbor One. And he's indicated to us that he's having to find other work because the city is not keeping him busy enough. And because Jerry Dunham is now doing all of those inspections. And he's a little.
hold on a second. So this is a 3rd-party person to do inspections. That's at least telling you that he could do more, but that he's not being requested to do more.
Correct. He's Jeff Schaefer.
Stop there for a second. What do you know anything about that? Huh?
And here comes the hearing's first real, what are we even doing here moment. Because now the property side raises a potentially explosive point. A third-party inspector may be available to do more inspections, may actually want more work, and may not be getting used. If that's true, that is exactly the kind of fact that can drive a judge crazy. Why? Because it transforms the problem from capacity is limited into capacity may exist, but nobody's using it correctly. Judge Simpson catches it immediately. He doesn't let this drift by as just another complaint. He zeroes in on the operational question. If someone can do the inspections, why are they not being deployed? That's a judicial red flag. Courts can tolerate complexity. They can tolerate disputes. What they have very little patience for is preventable inefficiency when people's housing conditions and court-ordered deadlines are involved. And notice the deeper significance here. The defense is not just arguing that the city has been hard to work with. They're suggesting that the city, or its inspection process, may be leaving available resources on the bench while the deadline approaches. That is a much more powerful narrative because it implies the bottleneck is artificial, not inevitable. Question for the audience. If an outside inspection contractor is available and willing to work, should the city be expected to use that capacity aggressively to avoid delay, or is that oversimplifying how code enforcement actually works?
Okay, go ahead.
Yeah, our property management team spoke with Jeff Schaefer, who is an employee of Code Enforcement Services, CES, the company that the city contracts to do the building inspections. Jeff indicated that he's not being kept busy enough with do work now and has to reach out to others, get work from other municipalities because Mr. Dunham is now doing the inspections that he previously did. This is, on top of the scheduling, this has been an issue for us as well because working with Jeff, the process was, streamlined. We would do the inspections. He would give us yellow cards, letting us know the inspection results, and we would be able to, continue on from there. We now have Jerry doing those things. We're running into we're not answering the phone. We're not letting you know when we're coming. We're not calling, as well as you're not giving us inspection cards. So we have no verification at a certain point to establish whether or not we passed or not, which is problematic from a property management perspective. With the city coming out, we want to be able to verify when an inspection is passed and when it's not. So at this point, their position has been that they're not required to give them. But up until this point, we have always received them from CES. So just something we wanted to flag with the court as well, because these are things that are.
Well, hold on. Can this guy do more inspections?
So there are, per our contract, and
Whose contract? With who?
the city and CES,
Okay.
we can do 6 inspections a day.
This is one of the most revealing moments in the hearing, because Judge Simpson stops acting like a passive referee and starts acting like a problem solver with zero patience for bureaucratic nonsense. The second he hears there may be inspection capacity available, he doesn't say, "Interesting, let's revisit that next hearing." He says, essentially, "Get on the phone right now and find out." That is a judge trying to force reality into the room. And frankly, it makes sense. By this point, the hearing has become a maze of, we submitted this, they didn't accept that, we requested inspections, they didn't call us, someone else could maybe do more, and the deadline is still coming. Simpson's reaction is the cleanest one in the room. If there's a human being who can perform more inspections and move this process along, then stop theorizing and confirm it. That's a powerful courtroom moment, because it shows what the judge sees as the core issue, not who has the best rhetorical complaint, not who can give the longest explanation. The issue is whether these buildings can be pushed toward compliance by the deadline, and if so, what concrete mechanism gets them there. If more inspections are possible, then that's not trivia. That's potentially the difference between hitting May 20 or crashing into another delay.
We have done more than that over the last 2 weeks, and we have yet to,
With this company?
with both with Jerry and this company, to make sure we get the inspections done.
All right, get on the phone right now, find out how many inspections he can do in a week. Let's do it right now. Because this doesn't make any sense to me. If somebody can do the inspections, then let's get them done.
Another issue I was hoping to bring to the court's attention.
Sure, go ahead.
So some of the tenants that have been relocated both in and out of court to the township side, they've continued to escrow their rent. And now they're receiving 7-day notices to evict them. One of those people, Miss Natasha Drake, is in court today.
So she's receiving a 7-day notice with, but they're on the township
on the
side.
township side, but she's been escrowing her rent
Here.
this case. Yeah.
Okay. And she's escrowing it on her case right here, right? Okay, so just so that you know, and we haven't quite worked it out, Judge Washington is aware who would be handling the township cases. She's aware that the escrow is being paid here. How exactly that financial mechanism is going to work, we're not sure. Is the rental amounts the same? Or, well, that's going to be the part of the issue. The other part of the issue is who's going to be paying for that relocation, which is another issue. So
That's a twofold issue because, of course, we had our hearing with Judge Conkey last week on our preliminary injunction motion presented by the city prosecutor. That has not translated into an order yet for various reasons.
And now the case takes another turn, because just when you think this is purely about inspections and repairs, the hearing opens up into a second crisis: tenant relocation, rent escrow, and eviction notices. That is a dangerous combination. We're now talking about tenants who were moved to the township side, who are still escrowing rent, and who are also receiving 7-day notices. That's the kind of procedural mess that can spiral fast, because it means the housing problem has already spread beyond the original units and into questions of who owes what, where the money should go, and whether people can be threatened with eviction while the courts themselves are still sorting out the rules. The attorney here is essentially telling Judge Simpson, we've got overlapping court orders, overlapping jurisdictions, and no clean mechanism yet for how the escrow system is supposed to interact with relocation. That's a huge problem, because once you relocate tenants from condemned or non-compliant units into other units, the old assumptions about rent don't automatically make sense anymore. Are they still paying for the original unit? Are they paying for the new one? Is the relocation temporary? Is it permanent? Who covers the difference? And can ownership serve notices while all of that remains unresolved?
However, she addressed the issue of rent payments, relocation of tenants. She's made clear that tenants who are requesting relocation assistance can speak before her on 3 days' notice.
can do what?
Can appear before her with a motion on nearly 3 days' notice.
Okay.
She did reserve the issue of various things like emergency repairs, health and safety related repairs for a hearing. It was originally scheduled for 6/6 inexplicably. It appears that hearing's been moved to 6/20. Any tenant desiring to be relocated is to receive a 100% refund of all of their escrow funds and all of their paid rent from 9/17. So that would affect, obviously, the escrow order of this court once her order is entered, and also the escrow.
They're to receive what?
They're to receive a refund of all of their rent paid from 9/17 if they paid rent.
From 9/17.
9/17 of 2024, which was the date of the suspension of the certificates of compliance, and that they would be prohibited from seeking to collect rent while there are no certificates of compliance, because that's explicitly what the order or what the ordinance requires. It also prohibits leasing of buildings at the Arbor One property on the city side. Also prohibits all rent collections, that I believe I just said. And so she's looking at relocation on a case-by-case basis and addressing the
Has the,
term of refund of escrows on a case-by-case basis.
well, I'll wait to see her order. on that.
This section is a perfect example of why complex housing litigation becomes so chaotic so quickly. Judge Simpson is essentially staring at a three-board chess game at once. District court escrow, circuit court relocation rulings, and township-side tenancy issues all potentially touching the same tenants and the same money. And he sees the problem immediately. If one court is holding escrow, another court is dealing with relocated tenants, and a third proceeding is shaping whether rent should be refunded or prohibited altogether, somebody is going to end up with conflicting expectations unless this gets clarified fast. That's why Simpson's tone here matters. He's not just listening, he's forecasting the collision. He knows that if tenants are being relocated from the city side to the township side, and their rent is still being escrowed under an older framework, then every future question becomes loaded. Who gets that money? What period does it cover? What happens if the tenant stays? And what happens if the tenant leaves? This isn't abstract. These are real dollars tied to real housing instability. What I also like about this exchange is that the judge refuses to fake certainty where certainty doesn't exist. He doesn't pretend the answer is obvious. He says, in substance, I need to see the order and understand the scope before I start moving money around. That's disciplined judging. In a case this tangled, a rushed common sense solution can create an even bigger legal mess later. So yes, it's slower. Yes, it's frustrating. But this is one of those moments where caution is actually the responsible move.
Then deal with
There's
it.
a lot going on. Obviously, I'm not sure what you were aware of.
Mr. Henry, so what's going to end up happening is, even if it's going to be a bit problematic returning escrows, because the escrows may need to be paid, or at least these people could end up being relocated to the township side. And now you've got basically three courts with their hands in it, trying to figure out what to do. So I think between the three of us, we'll be able to figure it out.
You said Ms. Drake was.
Ms. Drake is one. I believe it was also Mr. Blankenship. Then there was some that were not in court, like Alina Jordan, Lawrence Grove, and Weena Harris Freeman.
And these individuals have all been relocated to the township side?
They were all originally on the city side, relocated to the township side.
Okay. Township side has COCs.
Correct.
Why are they still escrowing their rent when they are in a?
Because they wouldn't be on that side, but for what's happening on the city side.
I think another issue is they were relocated, given new leases, so they don't know if they have an increase in rent, a decrease, or if it's the same as previously. Some of them have leases that are ongoing, some the lease expired, so they've just been escrowing the same amount that they would pay either to the court or to the city.
And I mean,
I don't need, Mr. Beal, I don't need your comments. Go ahead. What were you gonna say?
so the court has ordered that even if they're on the township side with COCs.
I've ordered them to comply with my escrow order.
Okay.
This is one of the clearest examples in the hearing of Judge Simpson trying to preserve order in the middle of legal chaos. What he's saying here is important. As far as his courtroom is concerned, the escrow order still matters, even for tenants who have been relocated to the township side, at least until the bigger picture is sorted out. That is the judge trying to prevent the money side of this case from dissolving into total improvisation. And honestly, you can see why he's doing it. Without some temporary structure, everybody could start making their own assumptions. Tenants might stop paying because they've moved. Ownership might demand payment because the tenant is in a habitable unit. Another court might later say, the money should have gone somewhere else entirely. Simpson is trying to hold the center by saying, until we know whether this relocation is temporary, permanent, lease-based, or emergency only, I'm not letting the escrow framework just vanish. But this also exposes the core legal puzzle of the case. What exactly is relocation? Is it like a hotel stay while repairs are made? Is it effectively a new tenancy? Is it a temporary shelter arrangement? Or is it the beginning of a permanent move that changes who should be paid and why? The answer to that question controls almost everything.
And where they can either do it to the court or to the city? Because the question really is going to be, if they've been relocated, do they intend on coming back, or should they be paying for where they are? And I guess maybe the way to look at it is, it's one thing if they're in a new apartment and one can look at that in one way. Or you look at it from the standpoint that if they were placed in a hotel, then would they be paying the hotel bill? No. Right? So is this temporary? And I think and Mr. Henry, you can correct me if I'm wrong, but the real question is there relocation to the township site a temporary solution, or is that a permanent solution that at some point that's where that person's going to be?
Right, and I think that would kind of speak to the answer to his question, is speaking with all these individuals to see if they intend to stay in the township side, or if their intent is to, again, be relocated back to their unit. If they intend to stay, then I think that conversations should be had about whether or not they should be paying rent.
Well, and whether or not they have a lease.
Right, and then,
I mean,
you know, further.
I would agree with you in that respect, but remember how this all started. It all started because the units on the city side were not in compliance, so these people had to be relocated. The people get relocated, and some of them are put in hotels, some of them are put in other units, with no clarification as to the permanency of any of that.
And this is the exact point where Judge Simpson boils the whole relocation mess down to its rawest form. The tenants were displaced because the city-side units weren't compliant. People were scattered into hotels or other units, and nobody seems to have clean answers yet about what any of those placements actually mean long-term. That is the heart of the problem, not just where people are sleeping tonight, but what legal status attaches to that move tomorrow. This matters because permanency changes everything. If a tenant is in a hotel temporarily while their original unit is repaired, that's one set of obligations. If they've effectively been transferred into a different apartment and intend to stay there, that's another. If they're moved but never given a new lease, that creates another layer of uncertainty. And if escrow money is still flowing while all of this remains undefined, then every party has a financial incentive to interpret the arrangement in the way that helps them most. What Simpson is doing here is classic judicial framing. He's stepping back from the weeds and saying, before we fight over rent, escrow, notices, or reimbursement, we need to answer the basic factual question: did these people temporarily relocate, or did they actually move? That distinction is the hinge for the whole financial side of the case.
So,
if I may, Your Honor, it seems if somebody's been relocated to the township side in a certified unit, they are certified, that and they wish to stay there, they like the accommodations, and are willing and able to sign a lease or a lease extension, that rent should resume. It's there's no health, safety, or certification issues that would include the landlord from requesting rent for a certified unit that the person intends to reside in.
if they have a lease.
Yes.
I don't know if any of these people have leases.
That's my understanding, that they don't have leases. Ms. Drake, is that correct, that you don't have a new lease?
I'm sorry,
That's correct.
you don't have a new lease. Yeah. So, I mean, ultimately, the real issue is, are they intending on staying there? Have they moved, or have they, I guess, for lack of a better term, have they relocated or have they moved?
Right.
That's really going to be the issue, as far as I'm concerned. But
And we can, obviously, I can communicate with legal services about having those conversations to see if some of these issues could be resolved. Because I think that, this turns on a few of those questions that I don't think anybody has a clear answer to at this moment. So that would be the intent of the tenants would be.
do we get an answer regarding the inspections?
So not quite, but I have an answer that I think will satisfy. We have not denied any inspection at this point. We are running out of time for the 20th. But we have made it work. We might not be able to make it work with the timelines that they want, like end of day Friday.
This is one of those courtroom moments where the wording sounds reassuring, but the subtext is anything but. The city representative is basically saying, we haven't denied any inspections, and we've managed to make it work so far. On the surface, that sounds like a defense against the property side's complaints. But listen carefully to what's tucked inside that answer. They're running out of time. The requested timelines are tight, and they may not be able to accommodate last-minute demands the way ownership wants. That is not a clean all clear. That is a warning dressed up as a status update. And Judge Simpson immediately sees the real issue. He doesn't care whether the city has technically denied an inspection if, in practice, the timing still makes the May 20 target unrealistic. That's the key distinction. A case like this can fail without anyone formally refusing anything. All it takes is a slow permit pull here, a delayed special inspection there, and a few scheduling bottlenecks stacked together. Suddenly, the deadline dies from accumulation, not sabotage. What makes this section so important is that it confirms the hearing has moved past blame and into feasibility. Can the inspections still be completed in time to matter? Can the work still be approved in time to matter? Can the city's schedule and ownership's repair pace still line up before the court's calendar catches up with them? Those are the questions now.
And Monday, when we don't have any inspectors. But we have yet to deny one inspection. And so
I don't know that that's what I asked.
and I have gotten back to our company that does it. And so
Pardon?
I have a call in and a message to call me back because I'm in court, but I have not gotten a call back from CES.
Wouldn't that really dictate in certain respect whether or not the 20th is going to be able to happen?
If the boots on the ground are telling our boots on the ground the 20th isn't going to be happening.
What?
So even our boots on the ground are hearing from their people that they're not likely to make the 20th. They're only pulling permits on certain things. Even last week, as you heard from them, there's certain permits that haven't even pulled. They haven't hired the person to pull them, and that's been 2 weeks ago that they agreed to pull those. So with issue, the city's not the problem here ultimately, Judge.
Well, I think everybody's a problem because what I'm hearing is I don't think people are communicating. I think people are getting in certain ways for whatever the reasons are. And that's fine if everybody wants to act that way. I mean, I certainly will let Judge Kunke know what I am seeing on my end regarding that. But, if I mean, just by way of example, if one side is hearing that somebody can do more inspections, but for whatever reason, those inspections can't be done, that doesn't make any sense to me. I mean, it's like everybody's talking two different scenarios here, which makes no sense to me.
Meeting we had here a couple of weeks ago, they asked us to attend, and one of the items that came out of that was an insistence on our part and agreement with theirs. There would be a single point of contact. So we didn't have this, he said, she said folklore, from whoever it's being spoken to. We identified who we wanted to have as our single point of contact. And it was our understanding that they would do the same.
This is a subtle but very important section because it reveals the part of the case that almost always makes complex compliance hearings worse. Too many voices, not enough accountability. Counsel is reminding the court that after a prior meeting, the parties were supposed to establish a single point of contact, so this didn't devolve into a he said, she said disaster. And yet here we are, still hearing secondhand reports, still hearing different versions of what inspectors can do, still hearing different versions of what was requested, and still hearing different versions of who is slowing the process down. That matters, because in a deadline-driven housing case, communication is not some optional courtesy. It is part of compliance. If the city says one thing to boots on the ground, property management hears something else, counsel hears a third version, and the court hears a fourth, then the entire process becomes vulnerable to delay, finger-pointing, and plausible deniability. Everybody can always say, "That's not what I was told." And once that happens, nobody owns the failure. Judge Simpson has been circling this point for a while now. He doesn't just hear repair disputes, he hears structural dysfunction. That's why the single point of contact issue matters so much. It's not administrative trivia. It's the difference between a coordinated compliance push and a courtroom full of professionals explaining why they all somehow walked away with different understandings of the same plan.
You know, when there's a disconnect like that, again, that we try to address.
How many inspections on 720 and 721 are there this week?
8.
That's all that's been requested.
Yes.
Is that correct, Council?
8 have been requested. 8 are scheduled.
You said you had the punch list of what needs to be done.
Yes, I have 2 documents that are the rental inspection correction notices, one dated April 3rd, one dated March 31st. And this appears to be the most recent list, and it's laid out by what's been done, and then notes from the property management team as to plan to get those things done by the 20th. So yes, I can email that to Ann.
Okay. And I guess my question is, that list, is everybody operating off of the same list?
Yes. I think so, yes, Your Honor.
Really? Are we,
I mean,
So-
it's the city's correction order list, so we're working, yes.
is that the latest one? All right. And so the object is to get what's on that list done by the 20th.
Yes.
All right. Mr. Henry, was there anything else?
I don't believe so, Your Honor.
So the issue regarding the working out who's going to be where, how's that? Are you just going to reach out to legal services and try to resolve some of those things?
I'll communicate with legal services, and we can see what information they can provide us regarding the tenants as to their intent to stay or go. And then from there, I think we can have conversations on leases and things of that nature.
And if you have a list of we received those 7, 8 notices, we could probably try and reach out to many of those we can to see what their preference is or what their plan is going forward.
And I'll just make a note to, I don't know that I'll see her this week, but I'll touch base with Judge Washington just so that or Magistrate Bailey, just to make sure they're aware what potentially could be coming down the pipe on those. Those, and I don't know if anybody can answer this, those cases would be filed in the name of Arbor One or the Phillips. How would those cases be filed in the township? Mr. Friedman, do you know?
Mr. Beal's using his regular landlord tenant attorneys for that, Your Honor, and I'm not involved.
Got it.
I'm not aware of it either.
Okay. Then I'll let her know that I have no idea, but they're there. Okay.
Once we establish whether or not tenants intend to stay on the township side, to the extent that they have been escrowing their rent while on the township side, is that rent then being released as rent to the property?
Say that again.
So tenant A been on the township side, been relocated for a month. There's a COC over there. We set up a lease with this tenant just to kind of establish what's going on. She escrowed her rent for that month. Is that rent now being released to the property?
Okay, so here, that's going to be a complicated answer.
And that may be the understatement of the hearing. That's going to be a complicated answer, is Judge Simpson's polite way of saying, this escrow situation is a legal knot, and nobody should act like there's an easy fix. The hypothetical being posed sounds straightforward. Tenant gets relocated. Tenant escrows rent while on the township side. Tenant signs a lease there, so does that escrow get released to the property? But once the judge starts unpacking it, you see why the answer is so messy. If there's a case filed in township court, Simpson would prefer to send the money there and let that court handle it. If there's no case filed, then maybe the numbers have to be sorted manually later. But hanging over all of that is the possibility that circuit court could order money returned to tenants under certain circumstances. That means the district court could be sitting on funds that one court thinks should go to a landlord, another court thinks should go to a tenant, and a third proceeding may not have fully clarified yet. That is exactly the kind of multi-court conflict judges hate, because once money is dispersed the wrong way, unwinding it is a nightmare. This section also shows Simpson's instincts as a judge. He's not eager to improvise with other people's rent money just because the hearing is messy. He wants clarity, and until he gets it, he's trying to keep options open rather than lock the court into a distribution that might later conflict with another order. That's cautious, but it's the right kind of cautious. In a case this tangled, speed without clarity is how courts accidentally create their own next emergency.
Because theoretically, if there's a case filed at 14B, okay, on the township side, my preference would be to release the funds to 14B court and then let Judge Washington make that determination. If there's been no case filed, and this is where it's really going to get sticky, my feeling would be that once all of that's worked out, then somebody would give me the numbers to just figure it out what needs to go here and what needs to go where. That would be my preference. But what's now being indicated is that there may be an order coming down from the circuit court that all the money is to be given back to the tenant, which means that anything I then have would have to go to the tenant to do with what they need to do. Now, I would seek, quite frankly, to try to get a clarification from the circuit court, or have somebody do that, get a clarification from the circuit court as to, in those instances, what should be done.
I think the circuit court order also is the caveat that these monies are being returned if the tenant decides to break their lease and leave. So.
Oh, well, that's wholly different.
Right, so.
What?
That was the point that Ed brought up.
So, okay, but let me ask this, because I'm not sure how one would interpret the order. Is relocating, but then the tenant makes the decision, I'm going to stay I'm going to stay now at this new place. Based upon what's being said, that money, the monies that would be held here go to the tenant and not to the landlord. Or is that not your understanding?
I don't think that would be my understanding. I think I think the tenant relocating, I think we're confusing two issues right now. So.
Oh, I'm not confused, but go ahead. No.
I think that there are some things with Judge Stunkey's order that are very clear. I don't think there's any dispute that it was decided that if a tenant decides they want to leave and break their lease and leave, that they can do that. There's no issue with them breaking their lease and leaving.
And that's really the breaking of the lease.
Right. So.
But a relocation does not fall in that category.
Right. That's where I was meeting. We were confusing two issues. So a tenant can decide they want to leave. They can break their lease. Arbor One is not going to object. If that happens, they can be refunded money that they've paid in escrow.
Got it.
They can be refunded rent that's been paid since the CFC period until the time they vacate. And then I believe that they would be returned a security deposit if they paid it. If they decide to vacate and leave.
Got it. Okay. Was there any?
Is that your understanding as well? I just want to make sure. That seemed very clear.
So it was more of a emergency motion, so as to help the people that were still located in the condemned units to get out as soon as possible.
This exchange is the hearing finally doing what it needed to do much earlier, narrowing the scope of the circuit court's emergency relief. Counsel explains that the emergency motion was aimed at people still stuck in condemned or non-compliant city-side units and was designed to get them out quickly. That's a big deal because it pushes back against the fear that the order silently rewrote every rent and escrow issue for every relocated tenant everywhere. According to this explanation, it didn't. And if that's right, then a lot of the confusion starts to make more sense. The emergency relief was focused on immediate safety and immediate escape from bad conditions, not on creating a fully developed long-term financial framework for every tenant who might later end up relocated, resettled, or released elsewhere. In other words, the order was triage, not a master blueprint. That's a critical distinction. Judge Simpson's reaction here is telling too. Once he understands that the order was specifically aimed at getting people out of dangerous units, the structure clicks for him. That doesn't solve every escrow problem, but it helps him separate the emergency purpose of the order from the later question of what happens when someone stays in a new unit, signs a new lease, or becomes part of the township side situation.
Correct.
I think that's why it was specific to those people.
Got it. That makes sense. Okay, so now to people who, and again, I'm gonna have to see the written order, but to people who are relocated, but then elect to stay, which was basically what Mr. Henry had brought, elect to stay where they've been relocated to. What's supposed to happen with their escrow? And please don't tell me it's silent on that.
I mean, the order did not speak to individuals receiving any funds back unless they were electing to break their lease and leave. So if somebody was relocated, I don't think that this order spoke to whether or not they would be entitled to any of those monies back.
Okay, and let me just say this. Based on what's explained to me, that makes sense, right? However, and I'm just talking technically, but it's not my order, so I don't know how to interpret it. Somebody being relocated, and then the conversation occurs, I'm going to now stay where I've been relocated. By definition, they then break that lease or that tenancy that they had. And so if that's the interpretation of that, then they fall into that same category. Just thought I'd throw that into the mix. But I don't know if that was the intent of what Judge Kunke was ordering.
And I'll speak for Judge Kunke, but my understanding of the hearing is that was not the intent. It was only specifically pertaining to individuals who are currently at the property on the city side who want to break their lease and leave the city side.
That may be a fight for another day. It just, because it just has to be some clarification on that. And that's going to, part of, as I see it, somebody, somehow or another, there's going to have to be some clarification of that. Because what's going to end up happening is at some point, the folks on the township side are going to file a case. And then it's going to be sort of one court, 14A may have the money, 14B has a case looking for the money, and the circuit court has issued some order. So somewhere along the line, that has to get clarified rather than everybody scrambling around trying to, at the last minute, trying to figure that out. Bless you, it seems to me. So, anything else we need to, now that I have this update, anything else we need to do prior to me giving the next date?
Your Honor, Todd Ryan, appearing by Zoom, permission to speak briefly?
Yes, go ahead.
So Todd Ryan, P81848, representing plaintiff prosecutor in the circuit court matter, not a party, speaking as a friend of the court, and informed the court regarding that recent conversation about the scope of the order. That is going back before Judge Kunke as to what exactly was ruled and was not ruled. Both plaintiffs and defendants have submitted proposed orders to the court for the court to finalize. But it was very clear on the record that it did not involve township properties, that the judge was focused, because that's what we presented, on the city side. And for the city side, the judge did orally rule that there wasn't a basis for escrow on the city side with the lack of the C of C. but that was purely for the apartments, and that was kind of a necessary precondition to not ordering escrow on the city side alone. Again, that'll be going back before the judge on some other hearings on Wednesday, so it's very possible the judge
Not
will
ordering
clarify.
escrow on the city side. I don't. Okay, that's fine.
And so with the unusual procedural posture here with plaintiff prosecutor not being a party before your honor, and their separate claims for the prosecutor than for the tenants. I understand trying to get ahead of it and making the order as consistent as possible, but as I believe Counsel Henry said earlier, this was in the context of a preliminary injunction for emergency relief, and we're going to have a more protracted presentation and regarding where the money should go out of that emergency context.
Okay. So are you telling me the circuit court has vacated my order?
No, Your Honor. The circuit court orally found that she would not order escrow on that, and there wasn't a basis to do that for what was presented to her. And she did orally say that the tenants could submit this to district court and to the city of Ypsilanti for that court's consideration. But Your Honor, that may not be reflected in either proposed order.
Of course.
And I do have a recording of the hearing available, but to the extent, just thinking out loud here, to the extent Your Honor had questions to present to the circuit court because they impact your case, I wouldn't make a suggestion on that for Your Honor.
This is one of those moments where the legal posture of the case becomes almost as dramatic as the facts themselves. Todd Ryan is trying to be careful, very careful, not to tell Judge Simpson what he should do, while still acknowledging that the circuit court proceedings may affect what happens in district court. That's a delicate dance, and you can hear it. He's basically saying, I understand why you want clarity. I understand why these questions matter, but I'm not going to step into your lane and prescribe the solution. And honestly, that caution makes sense. This case is already juggling different parties, different courts, different kinds of claims, and different procedural purposes. The prosecutor's office isn't standing in district court as a standard landlord-tenant litigant. The circuit court emergency motion had one purpose. The district court escrow issues have another. The township side cases may have yet another. So Ryan is trying to give the judge useful context without becoming the architect of how those moving pieces should be reconciled. What's powerful, though, is Judge Simpson's response in the next section. He strips away the procedural theater and gets to the judiciary's actual goal: consistency. Nobody on the bench wants contradictory rulings, confused money flows, and litigants bouncing between courts weaponizing uncertainty. The attorneys may be advocates. The judges need the machine to work.
That what? You do what?
Oh, I'm I don't want to make a suggestion to Your Honor about what would be helpful for you. I was thinking of the context of like a certified question, but you know, this is a very different kind of procedural posture with a district court and a circuit court with different parties before each court.
I just called Judge Cookie if I had to try to figure it out. And then once I see a written order, I mean, I don't think on either end, and I would hesitate to say, not speaking for them necessarily, but with Judge Cookie, Judge Washington, and myself, I don't think anybody's trying to make anything complicated. It's just we need to know what to do, and so that everything is consistent. So, and sometimes that may not be the attorney's objective, but I think it would be the judiciary's objective. So, all right, thank you. All right. Did we get a call back on that inspect? Okay. So prior to our next date, I want an indication regarding these inspections so that, and if who is it, CES, if they're willing to put something in writing saying that they can do more inspections, I'd like to see that. And I guess I should clarify. Are they willing to do more inspections, and how many can they do a week?
And what's the cost?
Well, we'll figure out the cost. I mean, if somebody's got to put some money in there, what? But if somebody's got to put some money in there, look, folks, here's where I'm at with this. And just how I am. I don't like people coming here telling me why you can't do something. Find a way to get it done, and then let's figure out the nuts and bolts to achieve the objective. Because I'm hearing a lot of sort of naysaying coming from both sides about why we can't do something. And that doesn't make any sense to me. So you guys are looking to have this done by the 20th, which is a Tuesday. And let me ask you this. There would likely be, if you're trying to get everything done by that Tuesday, there would likely be inspections that would be happening that day, is what I'm thinking. Right. So maybe the next day would likely be the 23rd, which is a Friday, but what do I have on that?
Let me run.
Okay, so, but the 1 week adjournment from the 16th is going to happen, but those have become second hearings. So here's my thought, and it's just a guess, is have we set 23rd first hearing, Scott?
Yes, we have.
We're set this on the 23rd at 11 a.m. Okay. And council, so that you know, I know we have a bit of a delay, but I'll set it at 11 a.m. on that day. Oh, that's not going to work for Mr. Freedom.
Well, Your Honor, I finished.
Oh, okay. Fantastic. Okay.
I got a certificate of completion.
Fantastic. Congratulations on that, my friend.
Thank you.
All right. So we'll set it at 11 on that day. Okay. And then that way we'll see, and I will just let council know you'll be here in person. I will have Zoom hearings going all over the place that morning, but I will try to get them out of the way and make it as least inconvenient for you as I possibly can and get you in and out. Okay.
By the time we reach this scheduling discussion, it would be easy to tune out and think, okay, this is just calendar housekeeping. It's not. The next hearing date is strategic. Judge Simpson is deliberately placing the case after the May 20 deadline window so the court can actually see what happened, what got fixed, what got inspected, what got approved, and what excuses survived contact with reality. That matters because the entire hearing has been orbiting one central claim. We can still get this done by the 20th. Well, now the court is setting itself up to test that claim. And even in this lighter little exchange, certificate of completion, travel jokes, Zoom hearing chaos, you can still feel the underlying seriousness. The judge is making room for a follow-up where he expects answers, not just aspirations. By the 23rd, the parties shouldn't be telling him what they hope to finish. They should be telling him what is actually complete, what is still missing, and why.
I will be back in town.
Pardon?
I will be back in town for live hearings.
Yeah, I'm seeing that nice sunny sky behind you.
Yep. It's real.
Okay. All right. Was there anything else from either side then?
No, Your Honor.
No, Your Honor. All right, thank you. You're going to get that list to me.
Yes.
We can see where we're going to go. And I want an update sent to Ms. Weidling regarding that CES inspections.
Okay. Yes.
All right. Okay, thank you, folks. 14A stands in recess.
And that closing directive is the perfect summary of how Judge Simpson handled this hearing. He doesn't end with some sweeping philosophical speech about landlord-tenant law, and he doesn't pretend the court solved the entire Arbor One crisis in a single sitting. He ends by demanding specific follow-up, the updated list, the CES inspection information, and clarity before the next date. That tells you exactly what kind of hearing this was. It was not a final resolution. it was a pressure checkpoint. By the end of this case update, 3 things are crystal clear. First, the compliance work on these buildings is still a live race against time, and the biggest threat may not be one catastrophic failure so much as 1,000 smaller delays: permits, letters, inspections, scheduling, and plain old communication breakdown. Second, the tenant side of this case is now just as complicated as the repairs side, because relocation, escrow, refund rights, lease status, and township versus city jurisdiction are all colliding at once. And third, Judge Simpson is no longer interested in passive status reports. He wants hard answers. Who can inspect? How many inspections can be done? What remains on the punch list? Which tenants intend to stay? And what legal mechanism governs the money? That's the takeaway from this hearing. It wasn't about one dramatic outburst or one viral gotcha. It was about a court trying to impose order on a housing mess that has spread across buildings, tenants, lawyers, inspectors, and multiple courts. Simpson didn't fully untangle it here, but he absolutely made one thing clear. By the next hearing, excuses are going to have a much shorter shelf life. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.